appeal but heard in the matter of Alma Property Management Ltd and Crompton and another.
Yes. My lords, my lady, may I begin by just directing your attention to a ring binder that has hopefully been placed for all of you on the bench, which is Mr Dutton's supplemental bundle of authorities, to which I have added this morning, to avoid giving you a separate file which duplicates some of this, behind tab 10, and unfortunately, because this was only added in court, it's not written in the index, sections 14 and 15 of Talata, to which I will make brief reference in my submissions on ground 2. And also, just for convenience, so that they're not floating around loosely, to the extent that they may be relevant or of interest, the plans that I referred to yesterday are immediately behind the index in this bundle, and as I indicated yesterday, and there's no dispute about this, the first of those pages has the word roof on it, and it shows the flat roof edged in red.
Right.
Before I resume my submissions where I left off yesterday, may I just pick up on two small points that arise out of this supplemental bundle and go back to other matters that I was addressing yesterday. First of all, this is really just by way of information and to direct your lordships, your ladyship, to the relevant place. My Lord Justice Arnold yesterday asked about the relevant statutory provisions and the effect of a disclaimer. Behind tab 2 in this bundle is an excerpt from the Companies Act 2006 and section 117, which is at the very bottom of the 4th page in this clip, sets out the court's power to make a vesting order, and the Hindcastle case that my learned friend referred the court to yesterday is behind tab 4.
Yes, just before we get on to that. So section 114 tells us that the effect of Crown disclaimer is that the property is deemed not to have vested in the Crown under section 1012, which is bona vacantia. Then 115 says that operates so as to terminate from the date of disclaimer the rights, interests and liabilities of the company in or in respect of the property disclaimed. But it doesn't affect the rights, liabilities of any other person. And then, as you say, one then comes on to the vesting orders. So, as I understand it, the point about the Hindcastle case was that Lord Nichols was trying to wrestle with the fact that section 1015, which is what obviously the legislation one has to interpret and apply, is a bit odd because it doesn't destroy the property. The property continues to exist. And yet the rights, interests and liabilities of the company are terminated. But the rights and liabilities of any other person continue.
Indeed.
And so that presents a bit of a conundrum, and the answer is given in Hindcastle.
Indeed, and just for the court's reference, Hindcastle's behind tab 4,
Yeah.
and it's page 87 in the report. And what Lord Nichols did was to break down the combination, the combined effect of those two subsections into different scenarios. The first of which was a simple scenario which applies to the common parts lease, which is where there's only a landlord and a tenant involved. And next to letter F, as your lordship's just summarised, you'll see he said that disclaimer operates to determine the tenant's interest in the property, namely the lease. Determination of a leasehold estate has the effect of accelerating the reversion expectant upon the determination of that estate. The leasehold estate ceases to exist.
Well, I know that's what he says, but that's not actually what the section says. But anyway, all right, that's binding upon us.
Indeed. So that I hope answers the point that was raised yesterday. The only other point that I was intending to address up front, as it were, though I anticipate there will be a number of other points that my learned friend has to make on things that he's put in here that haven't been addressed yet, but I'm not going to try and anticipate those. The only other thing I would address is Jervis and Harris, which is behind tab 8 in this additional bundle. And as was rightly explained yesterday, one of the issues that was before the Court of Appeal in Jervis and Harris was whether a landlord's right of action under the sort of step-in right that we're dealing with, putting it loosely for the moment, is a claim that falls within the scope of the Leasehold Property Repairs Act 1938 and therefore requires the leave of the court. And that would only be the case if it falls within the rubric of the Act, which is set out at the top of page 202 in the report. And just beneath letter B, Lord Justice Millett sets out the question of whether the landlord's right to enter the property, effect the repairs himself, and then claim to recover the cost of doing so from the tenant is a claim for damages for breach of a covenant by the tenant to keep or put in repair during the currency of the lease, all or any of the property comprised in the lease. And then it's just worth noting he refers to a number of first instance decisions which pointed in different directions, some of which my learned friend made passing reference to yesterday, but I don't think any of those, I think any of them are in this bundle. And then he answers the question in summary form between letters E and F, where he says that the short answer to the question is that the tenant's liability to reimburse the landlord for his expenditure on repairs is not a liability in damages for breach of his repairing covenant at all. The landlord's claim sounds in debt, not damages, and it is not a claim to compensation for breach of the tenant's covenant to repair, but for reimbursement of sums actually spent by the landlord in carrying out repairs himself. And then he goes on to expand on each of those distinctions. I don't think I need to go into the expansive reasoning that he then gives. And the way this issue arose, that the court will recall yesterday, is in the context of the respective submissions on specific performance, where I say there's an available alternative remedy under clauses 6.2 and 6.7, which ought to be exercised rather than the court making an order for specific performance. And my learned friend's riposte in relation to clause 6.2 was that that isn't going to help the landlord because that is not a Jervis and Harris clause, as they're often referred to. That is an obligation which would fall within the scope of the Leasehold Property Repairs Act, and therefore there would be the additional hurdle which is within the bother, as my learned friend puts it, that would be associated with exercising that right. And so it's worth just comparing the form of covenant that was before the court in Jervis and Harris with clause 6.2. So clause 6.2 is at page 87 of the supplemental bundle. We've been through it, but the final two lines of the clause say that the expenses of such repairs carried out by the landlord shall be repaid by the company to the landlord on demand. Now, comparing that with what was before the court in Jervis and Harris, unusually that there isn't a direct citation of clause 210 of the lease, but it's it's summarised or set out in the judgment of Lord Justice Millett at page 201 next to letter F. And one has to assume that he is recording accurately what the clause actually said. And picking up 4 lines down, he says, the tenant is required within 3 months to make good all such defects or want of repair of which he has been given notice. And in default, the landlord or the superior landlords may do the work themselves and recover the costs and expenses of the work from the tenant on demand. And in my submission, there's no possible distinction of substance between that formulation, which was clearly held to be an action or a right that gives rise to a debt, and the formulation in clause 6.2.
My Lord, I hope this speeds things up rather than slows them down. If it slows them down, I will shut up as soon as that becomes apparent. The point I made yesterday was when you compare 6.2 and 6.7, 6.2 says the sum is payable on demand, and 6.7 doesn't.
Well, it's my fault. I misunderstood the way the point was being put. If we look at clause 6.7, the absence of the words on demand in my submission does not provide any basis at all for a distinction between the right of action that arises under clause 6.7 and the right of action that arose in Jervis and Harris. And I don't think really there's anything more at this stage I can say about it. This may be a submission that's developed in Mr. Dutton's reply. And if it's necessary to come back, I will, but I shouldn't have thought it will be. I think it's a short point. And in my submission, clause 6.7 is clearly on the debt side of the line. So that, my lords, is all I propose to say at the moment about the various bits and pieces.
Well, can I just ask you, what is exactly your interpretation of clause 6.7, so far as that is concerned? I mean, what it says is, if the company fails to comply, the landlord may at his discretion take all necessary steps, etc. And then the key words are, and recover the cost reasonably incurred in so doing from the company. Now, is it your submission that a demand is implicit in that? Or is it merely a question of timing, or what?
Well, yes, a demand must be implicit because a payment can't be sought in order to be recovered without being notified to the paying party. But what it can't be interpreted as is a provision that the cost reasonably incurred in fulfilling the obligations that the tenant hasn't fulfilled is being treated as damages in a way that would then engage the Leasehold Property Repairs Act.
Well, just taking it in stages. I apologise for being slow once again, but it seems to me the first question is, obviously you can't recover a cost without telling someone, the person from whom you're attempting to recover it, the amounts you're trying to recover. So I doubt it will be contested that much is implicit. But when it comes to timing, I mean, I would have thought that the point is different, because on demand usually means that the payment must be made and therefore the debt arises as soon as demand is made. Whereas this does not say on demand, and therefore it might be suggested that the obligation is to pay within a reasonable period of the costs being demanded. Now, firstly, would you accept that? Secondly, if you do, does that make any difference in your submission?
Well, I would be prepared to accept that because we say it doesn't make any difference. That the time at which the sum of money has to be paid it is not something that's capable of converting that obligation to pay from a debt to damages.
I mean, I believe there is authority to the effect that a sum payable in the future is still can still be a debt.
Indeed, and again, forgive me, not
I think
having...
Jarvis and Harris says that.
Well, it does. I'm just turning up the paragraph in it, where, as I said, I wasn't going to take you to, but where Lord Justice Millett expands on the notion of a debt.
He puts it quite widely, as I recall.
Indeed. It's page 203. It's really I mean, I won't read it out, but it's really the passage from moreover in the second paragraph through to, it's really addressed through to the end of the page, but principally the paragraph next to letter E. But there may be various reasons why there could be a dispute in litigation as to whether an obligation to pay a sum of money is a debt or damages. For this purpose, for the purpose of assessing whether it falls within the scope of the Leasehold Property Repairs Act as interpreted by Lord Justice Millett, the timing of payment, we would say, is not a relevant distinction.
Right. Thank you.
So that's all I have to say about the additional authorities and various mopping up points. So if I can return then to where I left off yesterday, and I had explained that we say that there are two points of principle in relation to which the judge went wrong in his provisional conclusion on reasonableness, as he put it. And I addressed the first of those, and I'm about to come now to the second. And the second in headline form is that the judge didn't, but ought to have considered the disproportion between the benefit to the landlord of getting an ARGA and the detriment that the tenant would suffer from having to enter into an ARGA. And I get that as a test that the court ought to apply from the international drilling fluids case. If I could ask the court to please turn that up. It's tab 11 of the authorities bundle. This was an appeal against a first instance decision that held that a landlord had unreasonably withheld consent to an assignment. And in the context of this appeal, Lord Justice Balcom, who gave the only judgment in the Court of Appeal, derived a number of propositions of law, as he puts it, from the various authorities that preceded this case. And we can pick that up at page 175 in the bottom right-hand corner. Just below letter G, Lord Justice Balcom says what I've just summarised. Many cases were cited, and from those he deduces the following propositions of law, and then they're numbered 1 to 7. And the one that I am suggesting ought to apply here is number 6 over the page on page 176. And what he said here is that there is a divergence of authority on the question in considering whether the landlord's refusal of consent is reasonable whether it is permissible to have regard to the consequences to the tenant if consent to the proposed assignment is withheld. And then he goes through the conflicting authorities and he reconciles them at page 177 next to letter C, where he says, but in my judgment, a proper reconciliation of those two streams of authority can be achieved by saying that while a landlord need usually only consider his own relevant interests, there may be cases where there is such disproportion between the benefit to the landlord and the detriment to the tenant if the landlord withholds his consent to an assignment that it is unreasonable for the landlord to refuse consent. And it's that statement of principle that we say the judge ought to have applied. I should just indicate that we would say, should this ever end up in a higher court, that we wouldn't necessarily accept that reflects the authorities that were cited, but that's not for a matter for this court. And then when we come to apply that to the facts, what Alma was seeking was an authorised guarantee agreement, which is a creature that was created by the Landlord and Tenant Covenants Act 1995, under which an outgoing and assigning tenant guarantees the obligations of the assignee, but the guarantee cannot endure for longer than the period for which the lease is vested in the assignee. So once there is a subsequent assignment, the guarantee ceases. But here, NTRML, who's taking the lease, isn't any old third party. NTRML is a company which is owned by the underlessees of the flats. And it had a special interest in acquiring what is, in essence, an onerous interest. And it is extremely unlikely to conceive of circumstances where any other third party might take it on. So we can't say that NTRML, if it takes an assignment, must hold the common parts lease for the remainder of the term, but it is very unlikely that there would be an assignment on by NTRML, and it's likely, and therefore the consideration that ought to be taken into account by the landlord in assessing the reasonableness of all of this, that NTRML would retain the common parts lease for a very long time. And therefore, in practice, it flows from that liability under an ARGA was potentially a very onerous one for these two individuals as receivers, or as former receivers at that point, to have to assume it could well outlive the individuals themselves and bind their respective estates.
At this point, we have to ask you about the postscript that you put into your second skeleton argument, where you informed the court, rightly, that at the end of January this year, NTRML informed the receivers that it no longer wished to take an assignment of the CP lease.
Yes.
And you then went on to say that the court was informed of this turn of events by way of information only, and said, I quote, it's not suggested by either party this has any material impact on the issues which arise on this appeal. And that seemed to me to be an odd statement when I first read it. It's even odder in the light of the submissions that you've just made. How do you reconcile the two, please?
Well, under the counterclaim, what the court is doing is reviewing a decision that was made at the time when consent to assign was sought and granted on condition in late 2020. And the court, the process of review, can't take into account matters that arise subsequently. Now, even though this development doesn't affect that process of review, and therefore it's not a fact that this court can or should take into account in reviewing the judge's conclusions on this issue, it might have been said that it renders that process, that the appeal on this issue, academic.
Indeed.
But for the reasons I've endeavoured to set out in that postscript in the skeleton argument, if that point were made, we wouldn't accept that the issues are academic for two reasons. First of all, it's possible that NTRML might be persuaded or might not even require persuasion once this litigation comes to an end, if it ends in a way that enables the receivers to assign, should NTRML be willing, to change their mind. If they don't change their mind, the allegation that we rely on, that consent was unreasonably withheld by imposing this condition, it is one that would be equally relevant to a cause of action that could arise, depending on what happens in the future, under the Landlord and Tenant Act 1988, in that we could, depending on how things unfold, have a claim for damages, for losses that this refusal of consent have caused to us.
What damages?
I'm sorry, my lord.
What damages?
Well,
what damages might you suffer?
Well, if there is nobody else who can take the lease, and if Alma resists taking the lease, we will remain liable as tenants for the interim period. We may remain, if that materialised into a dispute and were resolved against us, we may remain as tenants indefinitely if we can't find another assignee.
Yes.
And that potentially puts us to loss. It could be, because we would have our indemnity, so we would be able to rely on our indemnity as against Alma, but it could be that involves us incurring legal costs.
I thought we were still discussing the hypothesis that you lose on issue 1, so you wouldn't have an indemnity. Am I wrong?
Of course, I'm sorry. No, you're
but what you
quite
would
right.
have is you'd have your contractual rights under the deed of maintenance and under the lease to recover 49% from Alma and 51% almost from NTRML. So what loss are you exposed to? The lease is intended to put the lessee in the position of no gain and no loss.
Indeed, but the lessee is the primary obligor in respect of the tenant's
That
covenant.
I understand, but it is prima facie entitled to pass on 100% of its costs, and if it can't do so, that can only be because it's spent money on things which it shouldn't be spending, which it can't recover from, so outside the scope of its obligations.
Well, there are two ways in which loss could then be caused. It might have to incur costs in pursuing those debts, and there might be shortfalls if either of the parties obliged to pay those debts cannot pay. That there could be other remedies, but pursuing those other remedies would involve further cost.
Seems to me to be very difficult to assess a sum of damages for the prospect of you being stuck with a lease which ought to give you a right of recovery of 100% of the expenses you incur, although you conceive that in theory it might not. How do you go about assessing your damages?
Well, I can accept that it is not a straightforward assessment, and I might have difficulties, but where I would stop short is at this stage in accepting the suggestion that I can have no possible claim in damages.
Okay.
And the prospect of that claim in damages would turn on a cause of action under Section 1 of the 1988 Act, which depends on the landlord having unreasonably withheld its consent.
But my problem with this is a slightly different one, which is this all seems to me to be so unreal. I appreciate that part of the problem for both sides of the argument is that necessarily you're arguing about a hypothetical situation which may not arise. So all of this becomes academic if the judge is right that the receivers acquired the CP lease and pursuant to their powers. But we have to assume for present purposes that the judge is wrong about that. But we then get into this very unreal world, because on that hypothesis, well, in fact, even if the judge is right about that, I mean, I'm trying to get so confused as to the different hypotheses we are considering here, but we've got the trust-based analysis, if the judge is right, whereby Alma's position is you're bare trustees, and therefore it follows that they can call for the lease, but they don't want to call for the lease. But equally, looking at it the other way around, it said was section 6.2 of Talata applies, and you can force them to. So this all seems to me at the moment to be completely unreal, because there seems to be a fight which neither party is particularly keen to engage in as to whether the CP lease should end up in what might be thought to be a perfectly natural place, viz. Alma, or not. And Alma don't seem to want it, curiously, or not, depending on what you think of their economic interests. But equally, your clients don't seem terribly interested in forcing them to take it.
If the development that occurred in January hasn't changed, then that is the route that I will inevitably have to go down. When this claim for specific performance was served on me, and I was being compelled to perform the obligations under the lease, my response was to speak to the other parties involved, and NTRML expressed a willingness to take this lease. They appeared to be an ideal party to hold it. And given Alma's clear unwillingness to take this lease, that seemed to us, I accept hindsight, with hindsight this might now seem rather ironic, that seemed to us to be the more straightforward route to go down. And so we sought consent.
That is a curious use of the word straightforward.
With hindsight, my lord.
Yes.
We sought consent to that course as being the tenant. We were obliged to do under the terms that bound us in the lease. And the response to that request for consent was, yes, you can assign, but only on condition that you give us an ARGA. And this dispute...
Everything else follows.
And everything else follows.
Do we know, are you at liberty to tell us if you do know, why NTRML are no longer interested in taking an assignment?
We don't know. But I do maintain that that is a position that might change. That is one of the possibilities that could emerge after this appeal is decided. As I said, we haven't been told what the reasons are, but I think it's not a huge leap to make the inference that all of the bother that's been generated by this litigation and the associated delay could well feature in those reasons. I mean, I say that only by way of inference, but it is possible, one possibility is that they change their mind when this is finally determined, depending, of course, on what the outcome is.
Another possibility is that NTRML is only liable for, under the current arrangements, for 50% of the costs and can wait until those costs have been incurred before having to put its hands in its pockets, or rather collect the money from the lessees. But if it takes on the lease, it will have to pay 100% of the costs up front.
Indeed.
And have to recover 49% from Alma, which it may not want to do. I mean, I don't find that a particularly surprising commercial decision by the lessees.
No. And what we do know from evidence that was given by a director of NTRML at trial is that the reason that they agreed to take the assignment in the first place was that they wanted the building in which all of their flats are located fixed.
Yes, and taking the lease would give them control over the timing and the
Indeed.
Extent of repairs, as Mr Dutton said. Just because something is out of repair, it doesn't mean there's only one way of repairing it.
Indeed.
One can either spend more money in the hope of improving the value of their leases, or spend less money in the hope of that being good enough.
Yes, indeed.
So they would get that decision. But that's a matter for them.
Of course, and all of this sort of investigation into what influenced them previously and what is influencing them now cannot be anything other than speculation.
Yes. And doesn't affect what we have to decide.
Well, we say it doesn't, and I don't understand that to be opposed as between the parties.
What you were saying was that if you can't assign, if you're stuck with the lease forever, you might, or sorry, no. If you had given an AGA, you might be stuck with a liability forever. How long is the term? It was 130 years, was it?
I think so. Sorry, I don't have that at my fingertips.
From 1996, was it?
Yes, 130 years less 10 days from 1999.
So the prediction that your liability might outlive your clients' lives is a fairly safe one.
Well, I would say so, yes.
Yes.
Given the circumstances here, this isn't a commercial asset of any value that has any real prospect of passing on to any third parties.
Except, as Mr Dutton suggested, there might be people whose business is to manage properties who could see it as a way of giving themselves more business.
But would they normally take on that sort of liability as opposed to acting as an agent?
Well, it's conceivable, as indeed I imagine would be all sorts of alternative scenarios, but the likelihood would be that a person who's in that business would pitch for an agency role rather than taking on the direct liability.
Yes.
But is that not a question upon which the court would require evidence? We can't speculate as to the existence of such people or not. I mean, for all we know, evidence would show either that no such people exist or that there's lots of them. How can we know?
Well, it is a factual point, we say, that the court can infer from what we do know. We know what the nature of this asset is. It's an onerous interest. We know that NTRML has a special interest in taking that asset in its name. And it's difficult, I don't say impossible, but difficult to conceive of circumstances in which there would be a further assignment by NTRML, who of course would remain bound by the tenant's covenant not to assign without landlord's consent.
Well, we know the facts of the existence of the liabilities, both under the CP lease and the deeded maintenance. And we know that the income is dependent on the provisions of those documents being performed.
Indeed.
Draw some inference from that.
So I accept your lordship's point that there is no evidence.
It's not necessarily a problem for you.
What do we know about NTRML? Do we know that each of the lessees is a shareholder and the directors are lessees, or do we not?
Yes, we do know that.
We do know that.
Yes.
So it is a vehicle for the lessees to collectively own the head leasehold, which
Indeed.
is currently vested in NTRML. Is that right?
That's right, yes.
Yeah. And we know they've entered into a novation of the deed of maintenance covenant, so that collectively they are liable for the 50-something%.
Yes.
We assume, this will be in the head lease, that they have a right to no, not the head lease, each individual flat lessee, they have a right to reimburse themselves from the flat lessees.
Indeed.
Yes.
Yes.
Okay.
So, going back to the test that Lord Justice Balcom in International Drilling said can apply, and the judge didn't apply in this section of his judgment. He referred to it in the final section, but not in this alternative reasoning bit of his judgment. We say that this is a case where there is, quoting from Lord Justice Balcom, such a disproportion between the benefit to the landlord of having this guarantee and the detriment to the tenant of being bound by that guarantee in the circumstances that I've outlined. And in assessing the detriment to the receivers, although we're in a world here where Mr. Dutton has succeeded on ground one, so I took this lease in circumstances where it wasn't within my power as receiver, there can be no dispute on the evidence that I believed I was taking it as a receiver, and I took it in the course of my receivership duties in connection with the building. And so in this scenario that we're looking at, I made a mistake about whether or not I had the power in my capacity as receiver to take the lease. And that's
why
also,
is that relevant?
but that's relevant to the detriment that I suffer as a result of being bound by a guarantee in the circumstances that I've outlined, where I believed that this was a lease that I was taking for a limited purpose in connection with the receivership, and therefore never envisaged, certainly never intended, holding it beyond the life of the receivership.
It might be said that such a mistake could have been avoided by correct legal advice. I mean, I don't know, but that might be said.
Indeed. I mean, that's not an issue before the court, but depending on whatever legal advice was given, that's not a proposition I could disagree with. The legal advice that was given was before the court. And the step that was taken of applying for and obtaining the vesting order was taken on the basis of that legal advice.
We don't have the legal advice.
Not before this court. No,
We've got the judge's findings.
Indeed.
Yes.
So, I mean, that's really all. That's really what I say about this ground in the respondent's notice.
Can I just explore one thing you said, which was that given the potential length of the ARGA, it might affect their estates. What happens if you die with a potential liability which you can't crystallise? Does that stop you from distributing your estate to your beneficiaries forever? I think the point came up with some of the Lloyd's cases where names died with potential liabilities that had been crystallised.
I'm afraid I don't have an answer to that at my fingertips, my lord. That certainly is a possibility.
I have a feeling that there was a mechanism evolved for authorising executors to distribute on certain footings. But I may be wrong about that.
But we don't need to go that far. What we say is it would have a detrimental effect, however that materialises, on their estates after they die.
Thank you.
So, my lords, my lady, that's all I have to say about what my learned friend describes as issue 4. And so all that is left now is ground 2. And in order to address ground 2, I'd like to take this in 3 stages. First of all, I'd like to just say a word or two about what the status of the receivers is in relation to their holding of the common parts lease post-redemption. Secondly, what the effect of that status, which we accept is trustee status, what the effect of that is on the receivers as common parts lessee. And then the third stage it is really to address the ground of appeal, which is how does all of that affect my counterclaim for a declaration that consent has been unreasonably withheld to my assignment to NTRML. So under the first of those stages, just taking a slightly wider berth, before redemption of the charge, the receivers were deemed to be Alma's agents in relation to the exercise of their powers. That deeming arises under the mortgage conditions and under Section 109 of the Law of Property Act, and it doesn't matter which of those applies. And the nature of that agency was analysed by Mr Justice Lightman sitting in the Court of Appeal in the Sylvan Properties case. For your reference, it's behind tab 5 in the authorities bundle, and at page 84 in paragraph 27 there are 6 features or incidents of this deemed agency that are said to be significant. So just going through these very briefly, the first feature is that the principal, the borrower, has no say in the appointment of or the identity of the receiver, having committed management of the property to the lender. The second one, which might be thought to be obvious but is important, is that there is no contractual relationship or duty in tort between the borrower and the agent. So this isn't a contract of agency. It isn't agency in the contractual sense. But then, under number 3, there is an equitable duty owed by the receiver to both mortgagee and mortgagor. And at number 4, the duty owed by the receiver is owed to all of those interested in the equity of redemption, not just the borrower, so it could include post-ranking charge holders, for example. And at the top of page 85, he says that the class character of the right is reflected in the class character of the relief to be granted in a case of a breach of this duty. That relief is in order that the receiver account to the persons interested in the equity of redemption for what he would have held as receiver but for his default. And then at number 5, the primary duty of a receiver during the course of the receivership is to try to bring about a situation where the debt is repaid. And flowing from that, number 6, the receiver is not managing the mortgagor's property for the benefit of the mortgagor, but the security, the property of the mortgagee, for the benefit of the mortgagee. And the very end of that paragraph, he says the powers of management are really ancillary to that duty. Now that all applies, and there's no dispute about the application of those principles during the currency of the receivership. But then the charge is redeemed, and the receivers continue to hold property that they acquired in the course of the receivership. And once the charge is redeemed, the receiver necessarily no longer owes any duties to the lender, or at least not duties of the sort described in that paragraph by Mr Justice Lightman, because the debt has been repaid and that's no longer a purpose for which the property is held, or if it's not vested in the receiver, managed by the receiver. And as the judge stated on a number of occasions during the course of a judgment, redemption of the charge gives rise to a duty on the part of the receiver to account for property that continues to be held by the receiver. And as I said, that's referred to in a number of places in the judgment, but in particular in dealing with these arguments at paragraph 114, which is core bundle, page 73. What the judge said was he concluded that the defendants are right in their arguments that the vesting order was obtained and the common parts lease vested in them in the exercise of their powers as receivers. And then he goes on, that means that in principle, the defendants were acting as agent for the claimant and the common parts lease fell within the scope of the defendant's obligations to account to the claimant at the end of the receivership. The common parts lease, which was an important asset relating to the building, was not something that the receivers were entitled to retain for their own benefit. And as I think Mr Dutton said yesterday, it's to give effect to that equitable duty to account for the property that the law imposes a trust. So that it's held on bare trust for Alma.
The sort of trust arising under the law of Property Act does impose a trust on the proceeds of sale.
It does. I mean,
but this isn't a statutory trust.
No, it isn't. It's the closest I can come by way of rationale, and I think, there isn't a dispute that it must be a trust, but the closest I can come by way of rationale is by way of analogy of the position where somebody contracts to sell his property and during the currency of the contract of sale, where there is a specifically enforceable obligation to convey the property, the law imposes a constructive trust. Here there is an equitable duty to account for, to convey the property if called for, and it's as a result of that that the law will impose a trust. But
might it not be more closely analogous to a resulting trust? I'm not sure it actually is a resulting trust, but it's closer to that, isn't it? Because we're not dealing here on this hypothesis with a specifically enforceable contract to convey. And as we all know, that gives rise to a very peculiar form
indeed
of beneficial ownership anyway.
Yes. Your lordship may well be right in terms of categorisation. And we all know the difficulties of trying to draw bright lines between resulting trusts, constructive trusts, etc. But another analogy might be where property is transferred by mistake. It was a mistake that caused the property to be left in the hands of the receivers. They intended that the lease should be handed back with the freehold when the charge was redeemed. But
maybe you don't need to look for an analogy. Maybe all you need is, once the limited purpose for which the receivers held the property qua agent has come to an end, because their duty was to manage it as part of a security and the security has been discharged, as the judge says, they can't be holding it for their own benefit, so they must be holding it for somebody else, and that is a trust.
Yes.
If property is in the name of A, but it's not theirs beneficially, it belongs to B in equity, that is a trust.
Yes, indeed. And that's how my learned friend put it, and I would respectfully accept that. And as I said, there is no dispute between us that post-redemption, there is a trust by virtue of this duty to account. So then I come on from there to look at what the effect of this trustee status is on the receivers as common parts lessee. And the peculiarity which arises here is that post-redemption, Alma wears two hats. Alma is the landlord under the common parts lease, and it's the beneficiary under a bare trust of the common parts lease. And in our submission, it is very important not to get those two roles confused. And we would respectfully suggest that that is what ground 2 is doing. And I think it's instructive just to digress slightly and just consider for a moment how the relationship would operate if the landlord and the beneficiary are different people. Sorry, the tenant and the beneficiary are different people. If
No, I think
No, I was
landlord and the beneficiary.
yes, of course. Sorry.
They hold the freehold in their own name, personally.
Indeed. And they hold the lease on trust
And they are the Alma
for the freeholder.
yes.
So assume we have a scenario where A is the landlord, B is the tenant, and B holds the lease on trust for C. So as between A and B, landlord and tenant, B is liable under the lease to comply with the covenants. So B must repair the property, pay rent to A, and B, assuming an equivalent covenant, can't assign the lease without A's consent. But as bare trustee, B performs the obligations under the lease for C's benefit. And B's entitled to an indemnity from C in the usual way in respect of B's performance of those obligations. And C is entitled to call for the lease to be vested in him.
Can I just pick you up on indemnity? Every trustee, whether a bare trustee or not, has an indemnity out of the trust assets. But am I right in thinking that if it's a bare trust, the trustee also has a personal right of indemnity against the beneficiary for monies properly expended?
That is my understanding, my lord. I don't think that's a necessary part of this analysis.
Right.
If I'm wrong, so it's not a point I advance positively.
Yes. Okay.
Now, in that scenario, if B finds an assignee and wishes to assign to that assignee, B needs A's consent, and because B can't act in breach of covenant as against A. And if C does not wish B to assign, C would have to argue that the assignment will be in breach of trust. And if C isn't prepared to take the lease itself, depending on the circumstances, of course, that may be a difficult argument for C to make. But procedurally, C could, in theory, apply for injunctive relief to restrain the assignment, or if the assignment completes without an application for an injunction being made, or an application is refused, it's open to C to argue then that the assignment was made in breach of trust, and to either claim damages for breach of trust, or possibly in addition, an account of any purchase monies that arise on the sale, the assignment. Now, as between A and B, if A refuses consent under the covenant unreasonably, B might seek to challenge that refusal by applying for a declaration that consent has been unreasonably withheld. And as between A and B, landlord and tenant, if consent's required before the lease can be assigned, and it's subject to the proviso that it can't be unreasonably withheld, and consent has been unreasonably withheld, then Trelorum Big says that the assignment can proceed without being in breach of covenant. So that is an issue that could be disputed and litigated as between A and B. And we say that is a claim that B can bring against A, even if C is challenging B's entitlement to a sign. Now, in theory, it could be open to C to go to court to injunct B from pursuing that claim if B is using trust money to do so. But otherwise, B can bring the claim, and save for one point, the court must rule on it. Now, that one point is an important one, which is that the remedy that is sought in the claim by tenant against landlord, B against A, is a declaration. And the court has a discretion whether to make a declaration, and it could be said that the court ought to exercise its discretion not to make the declaration if there is a strong claim to restrain the tenant from completing the assignment in any event. Could be said that it would be academic. Now, in practice, what would happen in that tripartite situation is that C would join the proceedings and it would all be dealt with together. But the nature of the relationships and the causes of action that exist between A and B and C analytically are different, and it's important, we say, to keep them separate. Now, as between B and C, can B argue that the assignment is in breach of trust? Now, as we saw yesterday, the starting point is that under section 6.1, B as trustee, 6.1 of Talata, sorry, B as trustee has all the powers of an absolute owner, and so can complete an assignment and vest the lease in a third party. Now, C might argue that under section 11.1, if I should have turned this up, Talata's behind tab 20 in the authorities bundle, so we're not working from memory, and section 11 is on page 244. C might argue that under section 11, subsection 1, B must, so far as consistent with the general interest of the trust, give effect to the wishes of C as beneficiary. And B might respond to that by contending that retaining the lease in B's name rather than assigning it, depending on the factual circumstances, is not consistent with the general interest of the trust in circumstances where C is refusing to take it back. But
why is it not consistent with the general interests of the trust?
Well, it might be said, I'm just winding forward for a moment, that it is more consistent with the interest of the trust for an entity like NTRML, which has a direct interest in the management of the building, holding the lease, than the two receivers who have no such interest.
It doesn't look to me like the interest of a trust, but the interest of a trustee. The interest of a trust must mean what's for the interest of the beneficiaries as a whole, doesn't it?
Well, where there is a bare trust and a single beneficiary, as in this tripartite situation, the interest of the beneficiary is the proper and effective management of the trust property.
I see.
You mean rather than interests that go beyond that?
Well, there could be other interests that go beyond that, but that is an important interest that could be invoked in response to that claim.
But put it another way, it might suit the beneficiary to have a trustee with a deeper pocket. But I think you might argue that that was not within the general interest of the trust.
Well, I don't think I would need to go that far. I mean, what I'm doing is, before we come on to look at the specific, I'm just positing a potential defence that might be made.
I understand that, but it does raise another question, which is, in this hypothetical scenario in which B assigns to a third party, does the third party become a trustee, or do they take the property beneficially?
Well, we say they take the property beneficially for two reasons, effectively.
In which case, how can assigning it to somebody else lead to a more efficient administration of trust property? It destroys the trust property.
Well, it converts it if it has value.
Well, it doesn't have any value. You're not proposing to assign it to an NTRML for cash, are you? You're just proposing to assign it to them.
No, indeed. But that's...
So doing that just puts an end to the trust property, because NTRML take it beneficially. So there's nothing left in the trust.
Well, there isn't, but looking at it in terms of value, the trust asset has a negative value. It has
yes,
liabilities.
I can understand that a submission that disposing of onerous trust property to someone who's willing to take it is in the interests of the beneficiaries, because otherwise they might come under a liability to indemnify the trustee against onerous obligations. But I don't understand your submission that you made a little while ago, that it could be in the interests of the trust generally, because it would lead to better administration of the trust property, because it wouldn't lead to better administration of the trust property, it would lead to the destruction of the trust property.
Well, maybe the better way of putting that, because what I'm about to go on to is that the real answer lies in sections 14 and 15.
Which enable you to depart from the interests of the
indeed, but
beneficiaries.
Okay.
I don't at the moment think the general interests of a trust necessarily extend beyond the general interests of the beneficiaries as a whole. What I think Section 11.2 is dealing with is a case where you have, say, 10 equal beneficiaries, and 7 of them want something and 3 of them don't, but it's not actually in the interests of all 10, and the trustee can depart from it.
But I mean, you have my submission on that. As I said,
yes.
That's not really.
Anyway, all you're doing is identifying arguments that might be put forward.
Yes.
Okay.
Yes.
It may also not be relevant to get to this, but I think I'd want to understand better your suggestion that the trust would be destroyed on transfer, to the extent that's relevant.
Well, if there is no purchase money that flows from the transfer.
I was thinking more whether the transfer is subject to the trust.
As I was about to say earlier, we say there are 2 reasons why the transfer is not subject to the trust. First of all, Section 6.1, trustee is exercising the powers of an absolute owner.
I see.
And as a result of that, this is a scenario where the beneficial interest under the trust would be overreached on transfer, even if it doesn't give rise to purchase monies.
That is not how I would understand the law conventionally. I mean, you may have a point on registered land, which you may be coming to, but leaving that aside, it's not at all obvious to me that the effect of Section 6.1 is that somebody who is a donee of the property or transferee without giving valuable consideration, as opposed to a purchaser, would take free of equitable interests. What you may say is that taking the lease in this case, even if not for cash, is still for valuable consideration, and so the transferee counts as a purchaser because they're taking on a liability on the covenants.
Well, indeed.
But I'm not persuaded that I don't think you get that simply out of Section 6.1. I don't think that enables people who aren't purchasers to take free of trust interests. I'd be very surprised if that was the case.
Well, it's Well, I'll put it under the banner of overreaching then, the principle that interested beneficiaries are overreached on a purchase. But it's, if returning to our facts, the common parts lease is assigned to NTRML, then I don't think there's any suggestion that NTRML would then continue to hold it on trust for Alma. And for these reasons, I would suggest that's quite right.
But in any event, since it's registered land, as soon as the assignment is registered, they would take free of the interests of Alma unless they had been protected on the register.
Well,
is that not right?
Yes, that is right.
But I think the covenant in the assignment to indemnify you against, well, no, under the Landlord and Tenants Act, your covenant comes to an end on an assignment, doesn't it? But taking on the liability on the governance in your place, I would have thought would constitute valuable consideration
Yes.
in any event.
Yes, but for the purpose of the overreaching provisions.
Yeah.
But what I'm looking at is potential defences, going back to my hypothetical scenario, that C might have, sorry, that B might have to the claim by C, that the assignment to a third party is in breach of trust. And even if B can't get there under Section 11, as I indicated, B could respond with an application for an order under Section 14, under which the court has to take into account the various factors listed in Section 15. And you should have these sections of the Trusts of Land Act behind tab 10 in Mr Dutton's supplemental bundle. And so, in effect, my response to the claim against me as B, that I will be acting in breach of trust if I assign, or that I have acted in breach of trust, would be to make an application under Section 14 for an order permitting me to assign to this third party. And the court has a much broader discretion than a trustee does, taking into account the limited factors by reference to the beneficiaries under Section 11. Now, all of this is hypothetical.
Yeah, I mean, so what could the court order? Because I can see it can't change the trustees.
Well, the court under Section 14.2 can make an order relating to the exercise by the trustees of any of their functions. And it could make an order permitting the trustees to sell the trust property, to assign the lease that comprises the trust property to the third party assignee.
Okay.
Well,
So
it can order them to do that. I mean, not in this type of scenario, but I mean, orders requiring trustees to assign property are regularly made under Section 14.2.
Well, indeed, orders for sale, as they're called,
Yeah.
at the behest of some or all beneficiaries. This is that situation in reverse, but the language of Section 14.2 doesn't preclude a trustee from seeking an equivalent order, and Section 14.1 states in terms that a trustee is included in the list of those who can make an application under the section.
and as I understand it, then relieving the trustee of the obligation to consult.
Well, that's
Yeah.
the effect
Yeah.
of it, yes. So bringing this back then to our situation where Alma is both B and C. As I said earlier, it's important to differentiate between Alma in its capacity.
So it's A and C, isn't it? The landlord.
Yes, I'm so sorry. Alma is both landlord and beneficiary of the lease. Alma could have argued that assigning the lease to NTRML would be a breach of trust. And then the receivers could have contemplated responding along the lines that I've suggested a trustee might respond to that argument. But in its position qua landlord, wearing its landlord hat, Alma's consent is still required to the assignment. And when consent was sought from Alma to assign the lease to NTRML in 2020, Alma didn't suggest then that such an assignment would be in breach of trust. Alma consented to the assignment, but required an ARGA to be given. But the condition of an ARGA is a condition which Alma imposes, and is either entitled or not entitled to impose as landlord. It has nothing to do with Alma's status as beneficiary under the trust of the lease. And so, how does all this then affect my counterclaim? Well, it is relevant, we say, to have regard to the way the case was pleaded and argued. My learned friend took the court to the pleadings yesterday, just for the sake of effectively proving a negative. It might just be worth going back to them. It's the defence and counterclaim where this issue was raised is behind tab 8. And at the bottom of page 113, paragraphs 21 to 26, we pleaded the request for consent to assign and the claimant Alma's response, which was to give consent subject to the condition, which we then argued was unreasonable. And it was in response to that that Alma pleaded in the paragraphs that the court was taken to yesterday on page 129. And at 15A, Alma admitted and averred the statement, the factual statement of the correspondence passing between the parties. Then at B said the defendants' actions as they're pleaded unequivocally demonstrate that at the time of those actions, the defendants understood that they were the beneficial owners of the common parts lease, and more particularly that they did not hold that lease as trustees for the claimant. Well, we would take issue with that, but it doesn't go anywhere in terms of the issues that arise on the claim or the counterclaim. Either we were trustees or we weren't. And our belief or understanding is of no consequence to that. And then that leads into subparagraph C, which the court was taken through yesterday. And again, this is all about what the receivers did or didn't believe to be their status at the time that they sought consent. But what Alma did not assert by way of response to the counterclaim was that an assignment of the lease would be in breach of trust.
Which they could have pleaded. I mean, in that case, is you're not trustees. But they could have said, if we're wrong about that, and you are trustees, then it would be a breach of trust.
Absolutely. It's that and that is effectively the alternative case that they are now seeking to run. But even if they had pleaded that, as I suggested earlier, the only way that cause of action that they might assert in their capacity as beneficiary might affect my claim against Alma as landlord would be in relation to the court's discretion to make a declaration. So it could have been said by Alma to the judge, well, you shouldn't make this declaration because the declaration is academic, and it's academic because even if we give our consent, this assignment will be in breach of trust. But that wasn't Alma's case. Instead, Alma defended the counterclaim wearing its landlord hat only. And it simply doesn't follow from that the counterclaim is not justiciable as it's put, or that there's some sort of procedural bar to me bringing this counterclaim to ask the court to declare whether Alma's consent was unreasonably withheld as landlord.
It might, on the grounds of circularity of action, affect a claim for damages against Alma under the Act, because you would hold those damages on trust for Alma, and that would be a good defence.
I could see that argument going back to the discussion we were having earlier about damages. It's the procedural bar that's referred to in Ingram applies in relation to a money claim, where it is met for a claim on an indemnity.
Yes.
That's the procedural bar that Lord Hoffman was talking about in Ingram. But to say that there's a procedural bar to bringing the counterclaim really assumes what it sets out to prove. It's assuming that there is some ground for dismissing the claim at the outset, which could only be the case if it's either an abuse of process or that it's liable to be struck out because there's no cause of action. And even if, which it didn't, but even if Alma had responded wearing its beneficiary hat to argue that the claim was in breach of trust, that would not make my claim for a counterclaim non-justiciable or amount to a procedural bar against it. It simply gives rise to a potential defence that was neither pleaded nor argued at trial.
If it had been raised, if they'd said, this is not something we want you to do, qua our trustee, if you are our trustee, what would your answer to it be? Because Mr. Dutton says it's just perfectly straightforward. You're a trustee. Your obligation is to hold the property or give it to us, but not give it to somebody else.
Well, we would have said, if you, Alma, are not prepared to take it, which is the premise that underlies all of this, we have somebody else who is prepared to take it, and we would have probably been thrown back to a Section 14 application.
Yes.
So one response to the request for consent to assign would be for Alma to say, oh, just give it back to us.
Indeed. Whatever we may take of whatever view we may take wearing our hat as landlord of the reasonableness or otherwise of an assignment to NTRNL, as beneficiary under this trust, we require you to assign it back to us. And in the very closing words of his judgment, the judge made the point that had that scenario arisen, he doesn't decide it because it didn't arise, but he doesn't see what the answer would be. And there probably wouldn't have been an answer. We're trying to offload it, and if our beneficiary seeks to take it themselves, it's not for us as trustee to say we're not going to give it to you, we'll give it to somebody else. But that is not the scenario that arose.
Sorry, just going back to what you said a moment ago. You said you would be thrown back on a Section 14 application, but I thought, as we discussed earlier, your remedy in those circumstances would be Section 6 too. I appreciate, this is all hypothetical. But the hypothesis here is Alma had raised the argument that an assignment to NTRML would be a breach of trust. You then said to Alma, well, okay, you take the CP lease back. And Alma had said, no. And why do you not then have the remedy under Section 60?
We would. That's an alternative way we could proceed.
Yeah. Thank you.
But again, this isn't a point that needs to be decided because it doesn't arise on the pleadings or indeed the grounds of appeal for that matter. But I would suggest that in circumstances where Alma is refusing to take back the lease and NTRML is waiting in the wings as a potential assignee, Alma would have an uphill struggle in seeking to restrain that assignment. But as we've said, there are various responses that we could have had.
Well, the court might put them to their election.
Yes, indeed. But of course, this is all hypothetical, and this is not the way the proceedings unfolded. So we come back to ground 2 of the grounds of appeal, and it's worth just having a look at what ground 2 actually says, because it's been put in various different ways in argument, written and oral. Ground 2 on page 15 of the core bundle invites this court to decide that it was not open to the judge to give judgment on the defendant's counterclaim. Now, we say that that is simply wrong. It's not a matter of whether it was open to him. There could have been defences along the lines that I've explored. Those defences weren't raised. And there's no basis for the argument that as tenant against my landlord, I could not make an application for a declaration that my landlord's consent was being unreasonably withheld, or putting that slightly differently, that my application for that order fell to be struck out.
Sorry, just to be absolutely clear, this gets directly at the declaration made by the judge.
Yes, that's right. Now, I've made all of those submissions without, I've alluded to it, I haven't gone to Lord Justice Millett in Ingram at all. We say that the way I've put it and everything I have said is consistent with the analysis of Lord Justice Millett in the Court of Appeal, on which the appellant is relying to advance ground 2.
And also on what was said by, I think, Lord Hoffman and somebody else.
Lord Hutton, yes.
In the House of Lords.
Indeed. And just for reference, it's probably worth just taking the court to the relevant passages. The Court of Appeal decision is tab 9 in the authorities bundle. And we've produced only the dissenting judgment of Lord Justice Millett because, as has been mentioned in a number of subsequent cases, that dissenting judgment was effectively adopted by the House of Lords as the correct answer. And the majority of the Court of Appeal took the view that a lease granted by Lady Ingram to her solicitor. Sorry, a declaration of trust.
I think it was the other way around.
It was. Declaration of trust in favour of her solicitor, subject to a lease granted back to her, was a nullity. That was the argument. That was accepted by the majority of the Court of Appeal, and Lord Justice Millett said that such a lease was not a nullity and could exist. And in this judgment, he was explaining how that is so. We don't need to go through the lion's share of the reasoning, but the relevant aspects of it for present purposes are on page 148 in the judgment. And first of all, just below letter A, when he's addressing the argument that this lease between these two parties infringed the two-party rule of contracting, he said, but a trustee who contracts with his beneficiary contracts as principal, even when he enters into the contract for the benefit of the trust estate and not on his own behalf. He contracts so as to make himself personally liable to sue and be sued on the contract, though he will usually have a right of indemnity out of the trust fund. The fact that he may hold the benefit of the contract and any damages which he recovers in trust for the covenantor does not make the contract nonsensical, still less void. And then dropping down to the next paragraph, it's important not to understate Mr. McFadden, that's the trustee, the solicitor's position. He was not independent of Lady Ingram, but neither was he a mere cipher. His duty was to deal with the land as Lady Ingram might direct. He was bound to convey the land to her or to whom she might direct, but he was not bound to comply with other directions which she might give. He could not have been compelled to grant the lease, though if he'd refused to do so, Lady Ingram could simply have found someone willing to do her bidding and require Mr. McFadden to convey the land to him. It's not, in my opinion, correct to identify Mr. McFadden's mind with Lady Ingram's for the purposes of the two-party rule. And then, picking up just below letter G, where the only objection to the validity of this arrangement is one of security of action, they are capable, the obligations between these parties, of ripening into enforceable obligations when third parties become interested. A covenant by a trustee with his beneficiary, the benefit of which the trustee holds in trust for the beneficiary, cannot, in my judgment, be dismissed as a mere whimsy. The covenant is good at law, but subject to equitable defences. Before 1873, it would have been enforced by the common law courts. It would not be enforced today, but only because enforcement would involve security of action. This is a procedural bar, not a substantive one. Once the security disappears, so does all objection to enforcement. If the covenant were a nullity from the start, it could not be resuscitated. And that's the point I made earlier about the nature of the action that I bring in my counterclaim. It's not the sort of action that can be subject to a security defence. That's the only procedural bar Lord Justice Millett posits for an action on the covenant between trustee and beneficiary. And that just doesn't arise in relation to my counterclaim. And Lord Hoffman in the House of Lords said much the same thing. So, in summary, therefore, what we say on ground 2 is that Alma could have defended the counterclaim on other grounds wearing its beneficiary hat, but it didn't do so. Even if it had done so, even the fact that it might have been entitled to do so, none of those things support the suggestion made by this ground of appeal that the counterclaim ought to have been dismissed in limine, as it were, that it was simply not a claim that could be brought. So, my lords, my lady, having taken, I'm afraid, somewhat longer than I budgeted for yesterday, they're my submissions on ground 2, indeed on all the grounds, unless there's anything else that I can assist with.
No, thank you very much.
Thank you.
My lords and my lady, if I could do some housekeeping points before responding. One of the questions that was asked yesterday related to the status of the hotel lease vis-à-vis the freehold. I do have office copies here. My learned friend has seen them. We don't think you need to see them. If I explain what they say, the position is that the freehold is registered at the land registry, and that's registered in the name of the appellant. The hotel lease is registered at the land registry, and that's held by, I think it's Premier Inns. The freehold title has noted against it the existence of the hotel lease, because as happens in the land registry, there's a schedule of notices of leases, and that is one of them. Now, the function of that schedule of notices is to identify the leases which are held direct out of the registered estate in question. So what the freehold title is telling us is that there are immediate tenants as set out in the schedule of notice of leases, and one of those, it happens to be entry 4, is the hotel lease. We've made inquiries of the land registry. There was an intermediate title. That title was closed in 2005. Now, the land registry hasn't been able to tell us the circumstances in which it was closed, but it seems to me pretty obvious, at least I think there is a very safe inference, that estate must have come to an end either by surrender or merger. Because otherwise the land registry would have closed the subordinate title as well.
It was probably a surrender, wasn't it?
Yeah. So that deals with that. The next point, there was some discussion. I raised Section 12 of the Law of Landlord and Tenant Covenants Act, and in the course of my learned friend submissions, it became at least potentially a point that we might need to spend a little bit of time looking at. And so, with your indulgence, that's what I will do. What we have to, as a backdrop, of course, we have to remind ourselves that the law of contract is qualified in relation to things which are frequently known as land covenants. So obviously under the law of contract, you can assign the benefit of a contract, but you can't assign the burden. In relation to property, and in particular landlord and tenant, there's been statutory machinery in place since 1540. The relevant legislation here is the Landlord and Tenant Covenants Act. That is the act which applies to all leases granted at the time this lease was granted. We find that behind tab 1. I've only set out extracts. I've included section 3. I haven't included section 15, which covers very similar ground. The only reason for including section 3 is so the court gets an idea of the scheme of the act. What the act does is it comprises an entirely new code about how certain types of covenant, the benefit and the burden, pass on assignments. And section 3 deals with that. And you see subsection 2 deals with assignment by the tenant under a tenancy. Subsection 3 talks about assignment by the landlord under a tenancy. And in broad terms, what happens is whether there's an assignment of the lease or of the reversion to the lease, if it's a landlord covenant, the person who is now the landlord is entitled to sue the person who's now the tenant. In relation to a tenant covenant, even if there's an assignment of the term or the reversion, the person who is now the tenant's entitled. Sorry, I've now can't remember which one I'm dealing with the landlord tenant covenant. But basically, the covenants are enforceable by the people who are currently landlord or tenant, depending on which of them is seeking to enforce it, against the person who's currently landlord and tenant. But of course, the company which held the common parts lease and was party to the deed of maintenance wasn't a landlord or a tenant. within the meaning of these provisions so far as the deed of maintenance is concerned. And that's why we need to look at section 12, if I could take you to that. And this deals with covenants with management companies, because although it doesn't happen every day, this is it is by no means unusual for a leasehold structure to include, normally be within the body of the lease, a party to the transaction whose sole function is to provide services for the building and to recover the cost by way of service charge. So it's someone who actually isn't the landlord or the tenant. What section 12 provides, and we see from subsection 1, is that it applies where there is someone who isn't the landlord or the tenant under the lease, but who is under that lease liable as principal to discharge any function in respect to any authorised premises. And then subsection 2 makes it clear that we are talking about someone who's liable as principal rather than as guarantor. Before we go on to the next page, we need to look at the definitions, which we will find in section 18. Sorry. Oh, I'm sorry, I got the wrong. I'm sorry, that must be misprint. It should be section 28. I don't have section 28. Do you have section 28? No. I apologise. Yeah. There has been an error, I'm afraid, in the copying, and I do apologise. I'm sure it was my fault. But if I can, we will supply section 28 to you. When we do, there are two definitions you'll need to look at. One is the definition of collateral agreement, and the other is the definition of covenant. Because when the Act talks about covenant, when it talks about a tenancy, a collateral agreement is defined as an agreement which is collateral to a tenancy, whether or not made at the same time as the tenancy. And a covenant of a tenancy includes a covenant contained in a collateral agreement.
So your submission is that the covenants in the deed of maintenance are covenants of a tenancy and within section 12?
Are my covenants that they were? Because we have to go back to section 12(1)(a) again. Because of course what we have to remind us of we'll get on to the guts of section 12 in a moment. Section 12 does not contain any mechanism by which someone who is the service provider is able to dispose of any interest or their obligations passed to third parties. There's simply no provision. And so when we look at section 12(1)(a), we see that the section only applies where there is someone who, under a covenant of tenancy, is liable to discharge any function. So it is, so in order for section 12 to apply, there must exist a person who has a contractual liability to provide those services. So we know that before when the company existed, we know that section 12 applied. It looks as though, however, section 12 ceased to exist when the company did. Sorry, so section 12 ceased to apply when the company ceased to exist. The reason for that being that as soon as the company ceased to exist, there was no one who, under the law of contract, was liable on the company's covenants under the lease, under the management agreement. So it looks as though the deed of maintenance flipped out of section 12 when the company ceased to exist. If what we have to remind ourselves, of course, is that in fact it's probably sensible to go to the deed of maintenance. So if I could ask you to go to the supplemental bundle whilst keeping the authorities bundle out. The original deed of maintenance is at page 3. And you'll see the obligations, basically the company is under obligation under clause 2, and the tenant, that is the tenant under the residential head lease, their obligation is in clause 3. So the effect of the Act is that for the purposes of the Act, this agreement is collateral to the residential head lease. And while Section 12 applies, the effect of subsections 2 and 3 is that the obligations in relation to clause 2 are to be regarded as landlord covenants, so that the tenant, so that if there's a change in the ownership of the residential head lease, the new owner of the residential head lease has the right to sue the company by operation of Section 12. Likewise, if there's an assignment of the residential head lease, the effect of Section 12(3) is that if there is an assignment of the residential head lease, then the covenant in clause 3 will be enforceable by the company because those covenants are binding on the new owner of the head lease as if they were tenant covenants. But what the section doesn't do, as I say, is deal with any transmission of the benefit or burden of things looking from the company's point of view. And one obvious reason for that lies in the opening words of section 12(1). It forms no part of the application of section 12(1) whether the service provider owns any estate in land. In fact, what would normally happen would be that the service provider has no interest in land.
Sorry, is the point simply that Section 12 does not contemplate transfers by the third party?
Well, certainly it doesn't address them, that's right, absolutely.
It doesn't
absolutely. And so certainly in one sense it doesn't
in,
contemplate it.
In the positive.
Yeah. What inferences one can draw from that is slightly more difficult, but absolutely.
Okay, so where do you say that?
So what that means is, and this is simply a matter of building up the picture, what this means is that if it's right to say that under 12(1)(a), the reference to there being a person who, quotes, is under a covenant of tenancy liable, if that is referring to, if that is a forever speaking provision, as it were, so if it's one where the test is applied from day to day, then we know that when the company ceased to exist, Section 12, as I say, ceased to apply. And what that means is that at the time of the disclaimer, for example, the position was that the right under the maintenance deed was simply, their status was simply contractual obligations, contractual rights and obligations. So that the benefit could be assigned, but no burden could be assigned. But while the section does apply, the covenants in the maintenance deed have a kind of hybrid status. That is, insofar as you're talking about the right to sue the company for breach of clause 2, or insofar as you're talking about the right to sue the tenants for breach of clause 3, these are land covenants. But insofar as you're looking at the burden of clause 2 or the benefit of clause 3, these are simply ordinary contractual provisions. And that brings us to what I labelled yesterday the golden kernel, because the significance of section, the contractual relevance of the maintenance deed is obviously something that needs to be borne in mind when looking at what happened when the vesting orders were obtained. At that time, as I say, section 12 didn't apply. And if we look at the language of clauses 2 and 3, there are a couple of points to note as a matter, simply as a matter of contractual interpretation. The first is that when you look at clause 2, that clearly is not an obligation of indemnity. It's not saying, it's not a covenant of guarantee. The company is not saying, I promise that I won't commit a breach of the common parts lease. What clause 2 is saying is that I, the company, will perform all of the covenants that are set out in the document known as the common parts lease. In other words, this is incorporating the terms of the common parts lease into the maintenance deed by reference. And the significance of that, of course, is this. If you incorporate terms of another contract by reference, the contract whose terms you're incorporating doesn't need to exist in order for the contractual obligations under this agreement to continue. So this is something where the obligation under clause 2 of the maintenance deed is that the company will do the things which are set out in the tenant covenants in the common parts lease, and that will continue even if the common parts lease doesn't exist. Because this is a provision which was clearly intended to be collateral to the residential head lease and therefore regulates the relationship between the parties during the currency of that residential head lease. If we then go to clause 3, the point to note here is that, and this is a slightly less, I'm saying that this is a possible interpretation. This is one where you may form a different view, and in a sense I don't greatly care which view you form, so long as you appreciate that there may be nuances of interpretation. When you look at clause 3, it's at the very least arguable that the only costs which fall within the scope of the obligation in clause 3 are the costs that have been incurred by the person who's under the clause 2 obligation. So what that's telling us is this. At the time of the vesting order, we have a situation where no vesting order could impose upon the receivers the obligation imposed by clause 2 of the maintenance deed. So if the maintenance deed is vested in the receivers, that does not make the receivers liable contractually under clause 2. And the reason for that is that the obligations imposed by clause 2 are purely contractual obligations that bound the company, but those obligations are non-assignable as a matter of contract law.
Maybe I'm getting ahead of myself, Mr. Dutton, but isn't this resolved by the novation?
Oh, absolutely, absolutely. Yes, yes, you're right. We'll come on to that in due course.
Okay.
If you're happy with me proceeding in that way. So, and then if we look at the benefit, the effect of the vesting order in relation to the maintenance deed was at least arguably to give the receivers the ability to recover the cost of services, But there was at the very least an argument that would have been available to NTRML that its only obligation to pay services under clause 3 would be in relation to costs that had been incurred by the person who is under the clause 2 obligation.
I don't think I've quite understood that.
Right. The clause 3 obligation is to pay certain types of expenditure. Essentially, it is the initial provision service charge and the and so on. And we see that those are terms which aren't defined in this deed. They're terms that are used in the common parts lease.
Yes.
If we look at the definition of, so if we go to the common parts lease for a moment, we see that it's, if you go to page 93, gross annual expenditure, which for present purposes really all we need to look at, gross annual expenditure means ... all reasonable proper costs ... incurred by the company.
In providing the services.
That's
And
right.
the services means those specified in Part C of the schedule.
Absolutely. But they have to be costs incurred by the company.
Yes.
Now, when you then incorporate those terms into the deed of maintenance, then that would seem to refer. This isn't an important point. Maybe I'm just spending too much time on it. The really important point is that there is no clause, that the obligation to clause 2 can't have been foisted upon the receivers as a result of the making of the vesting order. As a result of that, where that leads us is that it may well be that services could be provided by the person who has the benefit of this deed after the making of the vesting order and recover the cost of services. But obviously it would be more satisfactory to do what then happened almost 2 years later, as my Lady Justice Falk has already pointed out, that is, enter into a novation deed. And there are 2 reasons why the novation deed was a very sensible thing to do. The first is because if there is any question about is it relevant who is the person who's incurring the costs, the novation deed will sort that out. But also the effect of the novation deed is that we once more have someone who is liable to perform services under the novated deed, so that the novated deed and its terms will become landlord and tenant covenants of the residential head lease once more by operation of section 12. So in other words, acquiring or novating the deed is something which, should we say, restores normality. It brings everything back into operation. And obviously there was some sense in taking a vesting order of the maintenance deed, whatever its meaning and effect, because that will almost certainly have given the receivers, should we say, an opening in negotiations with NTRML in order to secure an novation deed. But that then raises the question, well, where does the common parts lease fit into all of this? The answer is it doesn't. Obviously, if the person who wanted to get a vesting order of the maintenance deed didn't own the freehold, then obviously they would need a vesting order of the common parts lease. It's that common parts lease which, by obliging the tenant to carry out to provide the services, thereby permits them to do so as well. As you'll recall that the premises that are comprised in the common parts lease are less extensive than the premises in relation to which the services have to be provided. So the common parts lease, in saying you must provide services, for example, construction exterior, it must be giving the tenant of the common parts lease the right to carry out those works which are required. So if the person obtaining the vesting order of the maintenance deed wasn't the freeholder, they would need the common parts lease. But if the person who's seeking the vesting order of the maintenance deed does own the freehold, then there are no rights which are conferred by the common parts lease that they don't already have. Well, there are no rights they would need that they don't already have by right of the freehold. And so that's relevant when one then goes back to look at whether or not the lease was acquired in exercise of the powers under the charge. We start off with paragraph 7. And clearly, the common parts lease...
I mean 17.
17, I beg your pardon. Clearly, the common parts lease doesn't fall, or the acquisition of the common parts lease doesn't fall within that. Because the only thing that was needed for the business of the company was to acquire the contractual right of recovering service charges, which was contained in the maintenance deed. And you don't have to own the common parts lease in order to be able to operate the provisions of the maintenance deed. In fact, the common parts lease doesn't even need to exist to operate the provisions of the maintenance deed. And so that then means we're left with paragraphs 23 of Schedule 1 and the contractual right in 1544.
Can I just pause there? If you were the receivers and you had simply taken a vesting order of the deed of maintenance, you would be obliged on your construction under clause 2 of the deed of maintenance, I'll assume you're right, to carry out all the services.
Yeah.
And you would have under clause 3, again on your construction, assume you're right, a right to recover 50% from the tenant.
Yes.
But your other 49% you want from the landlord, Alma, and you get that under the common parts lease, don't you?
Yes, but Alma, if Alma is the person obtaining the benefit of which essentially it is through the agency of the receivers. If Alma is, or if the receivers are as owners of the freehold, obtaining a vesting order in relation to the maintenance deed, then they don't need a contractual right against the freeholder.
Because the freeholder.
Because that's a shortfall. Because they would be operating the whole charge. They'd have a right to recover 50+%, and they'd also be able to recover just about 49% from the hotel tenant under the hotel lease. And in the existence of a contractual obligation to pay the 40% that's contained in the common parts lease becomes completely o'shows. I don't know what you're looking at, but if you're looking at the hotel lease to see what that says,
yes,
the way that's in a much more modern form doesn't refer to the common parts lease at all. And so what it does, it gives the landlord the ability either to provide or to secure the provision of services, and entitles the landlord to recover a percentage of the cost of those services so provided. I can take you to the provisions if you want to, but the point is, you're absolutely right. One needs to look at it, but actually you won't find anything that's of any assistance to either party or to the respondent's case in there, because the obligation, as I say, it's a sophisticated modern service charge provision, which deals with as I say, where the obligation to pay service charge is not, it makes no reference at all either to the existence or the non-existence of the common parts lease.
It may be my own lack of understanding, but at the moment this is striking me as a new argument.
It is a new one. Or rather, it's a development, but it's a new development of an earlier argument, yes.
Okay.
But it goes back to the point that the only need that there could be, the only relevant need there could be for the common parts lease was if it provided some kind of accommodation that was needed in order to provide the services. And that's simply not the case. So that's what we say in relation to paragraph 7t. Moving to paragraph 23, there is no causal link, there's no link between acquisition of the common parts lease and selling the freehold with the ability to operate the service charge, with the ability to operate service charge provisions effectively. The reason of that being that that is something that was secured by the acquisition of the maintenance deed, not the common parts lease. That then brings us to...
Sorry, just for my benefit, you say, well, we could just have acquired the maintenance deed, you don't need the common parts lease. That would have required the agreement of NTRML, would it not?
No, because the obligation of NTRML is to pay the cost of the services in accord set out in clause 3.
But sorry, we're in a scenario where that contract has was disclaimed.
Oh, absolutely, and that's why one need. Oh, that's right. You needed it would be necessary to obtain a vesting order in relation to the maintenance deed. But my point is that that if you get a vesting order in relation to that and use that as a springboard for negotiating a novation, then that's all you need. You don't need the common parts lease. If we then... Sorry.
I'm being really slow, I think.
No, I'm sure you're not.
That vesting order, even though it's in a different person, on your scenario, let's say just straight into the freeholder or the receivers as agent, would have fully revived the obligations to pay on the part of the residential head lessee, you say.
What I would say is this, that if you get a vesting order in relation to the maintenance deed, then acquiring or taking a vesting order of the common parts lease as well adds nothing. Adds absolutely nothing. Because the contractual right to recover the service charges arises out of the maintenance deed. On a true construction of the maintenance deed, it doesn't matter whether the common parts lease is in existence or not, because the common parts lease, because the maintenance deed is a contract that's collateral to the residential head lease, which is intended to regulate the position during the currency of the residential head lease, and contains an obligation by which the company covenants to provide services, and it does so by incorporating the terms that are physically contained in the common parts lease. But that obligation wasn't contingent on the continued existence of the common parts lease.
Okay, the reason you say it adds nothing rather than is necessarily valid is, I think, when we discussed...
Well, it's two of the same. The point is that there was no reason for acquiring the common parts lease for anyone who wanted to operate the service charge machinery. The only time...
Okay, I think what I'm missing is that in our earlier discussion, we were talking about whether the third party in the Act could themselves be replaced. But you're assuming it can because it speaks not necessarily at the date of the lease.
Right. The position is this, that at the time of the making of the vesting order, Section 12 had ceased to apply.
Yes.
The making of the vesting order doesn't change that, and it still ceases. It's still not an agreement that, or there's still not covenants to which Section 12 applies. And the reason for that is that it is still the case that no one is contractually bound by Clause 2. And the reason why no one is contractually bound by Clause 2 is that under the law of contract, the only person who was ever contractually bound was the company, and that company no longer exists.
Okay. We're talking here about the benefit of Clause 3. Thank you.
So if we move then to the commercial mortgage conditions, we get those in the supplemental bundle starting at page 209. But of course it's 15 for the lead on page 221. The other power on which my learned friend relies, and it's a power that was referred to by the judge in his judgment only in passing, is 15.4 Roman 4 letter A, and that's the power to do all things which seem to the receiver to be incidental or conducive to any of the functions, powers, etc. And my learned friend says, well, if the receivers do, if it did seem to the receivers they had that power, well, that it was appropriate to acquire it, then that's an end of the matter. That, I think, was his submission yesterday. I would submit that that can't be right, essentially for two reasons. That is, first of all, there must be some basis in fact for the receivers to have that opinion. And secondly, they must have that opinion. If we go to the judgment, paragraphs 22 and 23, what we see is this. It's page 49 of the main bundle. Actually, it might be better if we start on paragraph 20. The dissolution caused a potentially serious problem for the defendants as the receivers. Only NTMC had the right to recover service charge from the claimant under the terms of the CP lease. Well, that's not right, of course. It had the right, but it was not under the CP lease, it was under the maintenance deed. Oh, sorry, I beg your pardon. I made a mistake. I misread it. I do apologise. They've got the right to recover it from, because the way to the claimant is to work the claimant. I do apologise. That's my fault. Only NTMC had the right to recover the service charge from the claimant under the terms of the common parts lease. But that's the point, of course, that my Lord Justice Nugee asked me about a few moments ago, and from NTRML under the deed of covenant. The 21, the defendants took legal advice, a letter was written. That means, then it concludes that meant for the time being the freehold of the building was not encumbered by the common parts lease. Common parts were back in the possession of the claimant. That's what we gained in paragraph 22. Then paragraphs 22 and 23, defendants' lawyers considered other options. And it says, for whatever reason, a second application was then made for an order vesting the CP lease in the defendants themselves. And we then get paragraph 23. When considering their options, the defendant's solicitors had approached the lender to seek an indemnity. Mr. Crompton told this was firmly rejected. The defendants decided to proceed anyway with the second vesting order application and didn't apply again for an indemnity. Mr. Crompton said it would have been pointless to ask again and frankly accepted that he and Mr. Cookson realised that taking the common parts lease in their names exposed them to potential risk. However, he said that risk wasn't great because the receivership strategy was to sell the receivership asset, and any purchaser would need to have control of the common parts lease to run the service charge for the building. But what he said there is just wrong. So we have a situation where someone, so they don't need the common parts lease. They've never needed the common parts lease. The only person, the only thing the freeholder needs is the benefit of the deed of maintenance, and either to acquire the common parts lease, or for the common parts lease not to exist. They'd secured the second of those had already happened by reason of the disclaimer, and so there was no need at all, no discernible reason why anyone in the receiver's position, properly advised, should think it was appropriate. And so the question then is, well, when condition 15.4.4a talks about how to do all things which seem to be incidental or conducive, is that complete carte blanche? And I would suggest not. It must be the case that yes, a margin of appreciation needs to be given to the receivers, but that whereas here the common parts lease adds nothing, it must be the case that the only real purpose, or the only appropriate course to take, would be to acquire the maintenance deed but not the common parts lease. Those are my submissions on that. Unless you've got any questions, I will move on. We now move to the Leasehold Property Repairs Act. But before doing that, I think we need just to get our mindset, as it were, straight. I won't be much longer, I promise. What we're looking at here is the question about whether specific performance should be granted. That's the context in which this consideration arises. In my submissions, I referred very briefly to the case of A, B, and C, D. That does repay, on the basis of what my learned friend was submitting, that does repay a little bit more consideration. Now, that was a case, and my Lord Justice Nugee has already referred to the puzzling suggestion that the inability to recover money should in some way not be relevant when exercising discretion. Well, what A, B, and C, D deals is in a case where the contract, which creates an obligation, imposed a contractual limitation on the quantum of damages. And the question for the court was whether the existence of that contractual limitation on damages meant that damages, or could mean that damages were an inadequate remedy for the purpose of the remedy of specific performance. And what is particularly instructive here is the fact that A, B, and C, D was decided actually on an interim basis. And so what the court was looking at here was, first of all, is the threshold, in fact, what it was principally looking at is, has the threshold for the court's jurisdiction arisen? Has the jurisdictional door been opened?
Applying American Sign Limit.
Absolutely. But
Is that the same test?
Well, it's not quite the same, because what it was asking itself is this: are damages a sufficiently inadequate remedy to open the door to the exercise of the jurisdiction? What the court was not doing was saying how that jurisdiction, if it arises, should be exercised. And so what this case does, it illustrates the difference. You recall I said that there were these several stages. this is, when you're looking at the threshold, the test for the adequacy of damages is a lower threshold. And the reason for that, we get that essentially in this sense. As I say, the court held that the fact that the contract imposed had a limitation on damages was sufficient indication that damages would be an insufficient remedy as to engage the jurisdiction. But what it then does is paragraph 30 on page 72 is consider, okay, now the jurisdictional gateway's been opened, what will the significance of that contractual provision be as and when the court finally comes to exercise its discretion? And the answer we get from paragraph 30 is that it will all be a question of fact and degree. It goes into the mix, but the weight you give to it is going to depend on what other factors are available. And what this does is it simply demonstrates the submission I made yesterday, which is this: once you're satisfied that there is enough of a reason to think that damages would be inadequate, you then go on to consider the balance of prejudice. That is, you say, in what respects would damages be insufficient, or would the claimant's common law remedies be insufficient? And you then say, okay, so we know what the detriment would be if the injunction on specific performance were refused. You then say, when exercising discretion, on the other side of the scales, if specific performance were to be granted, how would that prejudicially affect the defendant? And it is that process which is being hinted at in paragraph 30 of Lord Justice Underhill's judgment. But what we have to remind ourselves is this: in my learned friend's submissions, he did not identify any prejudice that the respondents would suffer if specific performance were granted. And as in all cases, therefore, if you're carrying out a balancing exercise and there's nothing on one side of the scales, you don't have to have something that's very weighty on the other side before you know which side the scales come down on. Now, of course, it's right that the remedy of specific performance will only be granted, is an exceptional remedy, and so on. That, of course, is right. But the reason why it's exceptional is that in most cases, there will be a balance of prejudice. And the court therefore has to strike the balance. And in striking that balance, the court will, as happened in the Rainbow case, need to be very careful. My learned friend is trying to turn points of the identification of weights that go on the scales as some kind of mechanistic test to apply when asking whether damages would be an adequate remedy. Clearly, if the claimant can't carry out the works itself, then clearly that's a pretty powerful reason for saying that specific performance should be granted. But if it's the case the claimant can do the works itself, that isn't a reason for saying a specific performance should be refused. It's simply saying that heavy weight that might have gone on the scales isn't there. So I say, in relation to the exercise of the discretion, that first of all, there was a discretion. The jurisdictional gate, the door was open, or should be regarded as open. And secondly, that the discretion should be exercised in favour of granting specific performance. And on the first of those points, that the doorway is open, I would remind you that in his judgment, the judge did not deal with this as a threshold matter. He clearly regarded himself as exercising a discretion. And you only exercise the discretion once the doorway to the exercise of discretion has been passed through. So that's that. If I may move on, but in weighing that, so in the context of that, we then get to the Leasehold Property Repairs Act point. Now, in relation to that, one point we have to remind ourselves is that normally, if there is a right to go in and carry out works under a lease, that will often arise in cases where the building is in single occupation, where the tenant who's under an obligation is therefore the only person who suffers in the short term if the building remains in disrepair. And in a situation like that, it's first of all much more easy to say, well, the landlord is being oppressive when seeking specific performance. And secondly, similar point, if the tenant's happy with the current condition of the premises and if it isn't causing any short or medium term problem, why grant specific performance now? So those are reasons why specific performance may well be refused in that type of situation. But we're a million miles from that situation. We're a situation where this is a building in multiple occupation, where the real role, the real function of the defendants here is not their role as tenant, it's their role as service provider for the whole building. And the grant of the tenancy simply gives them the right of possession in relation to some of the services that they're under an obligation to provide. And so drawing an analogy, or too close an analogy with other cases that deal with repairing obligations of tenants, is itself fraught with difficulty. But in relation to the Leasehold Repairs Act point, the point is a very short one, which is that if you look at 6.2 and if you look at 6.7, the language of those two provisions is different. One says that, in fact, it's probably sensible to go to it. So if we go to page 87, we see 6.2 is it concludes with the words, and the expenses of such repairs shall be repaid by the company to the landlord on demand. Compare that with the language of 6.7. It says the landlord can do the works and then continues, quote, and recover the cost reasonably incurred in so doing from the landlord. And so 6.7 is different in two ways. First of all, there's no reference to it being money that's payable on demand. And secondly, it seems to contemplate that before the money is to be paid, there will be some kind of determination of what is a reasonable amount. Now, both of those factors are capable of leading to the view that on its correct interpretation, 6.7 is saying that the measure of damages will be calculated by reference to the reasonable cost of remedial works, if those works are done. The learned friend has taken you to Jervis and Harris. I don't propose to do the same, partly because it's always 1 o'clock. But if I could take you very, very briefly, or at least point you in the right direction, in relation to Dowding and Reynolds. In the authorities bundle was an extract from Dowding and Reynolds. Could I ask you, if you don't mind, when you go to tab 5 of the supplemental bundle, to take out the contents of tab 5 and insert them immediately behind the passage that's already there. The reason being that...
Sorry, tab 5 of the...
So in the supplemental bundle, in the ring binder,
Okay,
you
we
go
don't
behind
have tabs.
tab 5.
You mean the supplemental authorities one?
No, sorry, I mean the supplemental authorities bundle. I do apologise. So if you wouldn't mind, as I say, I hope you don't think I'm being a bit cheeky in this, but if you would please to go to...
Well, where we put it doesn't really matter. The question is, what are you relying on?
Yeah, what I'm relying on is this. When one looks at Dowding and Reynolds, it's, as I say, it's the passage which is at the, which covers from the last page of tab 15 of the authorities bundle as it's provided to you, together with the first page of what's in tab 5 of the supplemental authorities bundle. The point is this: it's a question of contractual interpretation, whether or not a sum of a clause gives rise to a debt or a right to damages. Jervis and Harris certainly indicates that one shouldn't lean towards an interpretation that a sum is payable as damages. But, as I say, it's a matter of interpretation. And the fact that clauses 6.2 and 6.7 are worded so differently, one says, well, that must be because they intended those two provisions to have a different effect. That then brings me on to, there is the final case is behind tab 9 in the supplemental authorities bundle, a case called CDAC and Tanner. You need to be aware it's there, but really not much more than that. What that case makes clear is that if this is a case where the 38 Act applies, then you need to be applying to the court for permission to bring proceedings before the remedial works have been done. And so what that means in practical terms is that if either 6.7 is a provision that essentially gives rise to essentially liquidated damages rather than a debt, if that is the position, or if that's arguably the position and there is uncertainty, then what the landlord will have to do is it will have to assume that the Act applies. It will have to serve a notice under Section 146 of the Law of Property Act, giving in the form amended as required by Section 1 of the 1938 Act. It will then have to give the tenant 28 days to provide a counter notice. If the tenant gives a counter notice, the landlord will then need to apply to the court for permission to bring proceedings to recover the sum of money referred to in 6.7. I don't really think you need to know much more than that. It's simply additional uncertainty and additional delay. The final point, being aware of the time, is in relation to the trust's point. What we have to remind ourselves here is that the trial was conducted almost entirely on the assumption that the relevant law was the law of agency, where the receivers were saying that because they had once been receivers, therefore they were entitled to act essentially as principals in relation to deciding the person to whom the lease should be passed. And in his judgment, that's why the judge is using the agency analysis, simply because no one had argued the trust point before him. But as I have hoped to explain by reference to Ingram, an agency analysis just will not do, because property can't be held as an agent. What flows from that is that when the vesting order was obtained, and when the property became vested in the receivers, from that moment they held as trustees, if they were acting pursuant to their powers.
Sorry, when the receivership ended.
No.
Before
that,
that, we've been
as
taken,
soon as they
been
acquired
taken
it,
to the nature of the agency.
as soon as you accept that as a matter of English law, you cannot hold land as an agent,
Well,
as soon as you accept that, we know that when the property became vested in the receivers, it could either be vested in them as beneficial owners or as trustees. if they're acting pursuant to their powers as receivers, we know that they weren't acquiring it as beneficial owners. Therefore, there must have been what I would respectfully accept would be a resulting trust. Now, of course, initially, during the receivership, the existence of that trust didn't really matter very much because the receivers were the trustee, but they were also the they were also the LPA receivers of the person who's the beneficiary under the trust. So the legal significance didn't really make much legal significance at that point. But the trust nature becomes critical, of course, as soon as the receivership comes to an end. The reason why, what we now need to look at is the nature of the claim against the claimant by way of counterclaim. And that was a claim for a declaration. And we see the declaration that was made. It's on, I think it's page... sorry, I'm looking at the wrong one. The order that's under appeal is at pages 41 to 44. If we go to page 42, that's where it starts, and then go over to the page. The declaration that was granted was a declaration that the defendants are entitled to assign the lease without the consent of the claimant. Now, that's simply, if this is a trust-based analysis, that's an order the judge could not have made, assuming obviously he wasn't aware necessarily that this was a trust of land, although I'll come on to that in a minute. But if he was aware that this land was held on trust, that's an order he could not have made unless he was exercising his discretion under Section 14, and no one suggested he should exercise that discretion. So we have an order which is irregular in that sense, once we understand the correct analysis in relation to the relationship between the parties.
If a judge makes an error of law, it doesn't affect his jurisdiction.
It doesn't.
It means it's wrong. So
absolutely.
You could say should not rather than could not.
I'd accept that. The point is that the order that was made is one that now we know what the correct legal analysis is. That's an order that could not have been made without making an order under Section 14. Now, my learned friend says that there was no argument or no suggestion this property was held on trust. That's not quite true, because on the 2nd of November 2022, when there was argument after judgment before the order was made, and we get this in page 149 of, I think it's the same bundle. So this is a transcript of the proceedings in front of the judge. And if I could take you to page 149, page 13 of the transcript between C and E, if I could ask you to read that to yourselves, you'll see that it was suggested at that point that there was a trust, and on that basis it becomes very difficult to see how the receivers could be entitled to dispose of the lease to anyone, contrary to the beneficiary's wishes. So the point was raised in front of the judge. As I say, he probably didn't understand didn't see the significance of it because of the way the case had been argued. I'm not putting the judge at fault. It's just that's an explanation, I suspect, of why he thought it was appropriate to make the order he did. But here, where this is in front of an appeal court, and I say that the point that's raised there by Mr. Trumpeter in his submissions on the form of the order is absolutely bang on. And that's the case whether one looks at the position under the Trust of Land and the Appointed Trustees Act, or under the law as it stood before that, as set out in the Ingram case, because a trustee's primary duty is to hold the trust asset and to deal with the trust asset as the beneficiaries direct. Everything else are mere functions, but the essential duty is to do that. And what the respondents were purporting to do, and have been purporting to do, is to act in a way that is inconsistent with that duty. Now, while obviously there was an issue before the judge about whether or not the property was acquired pursuant to powers, clearly the counterclaim, we can't object to the fact the counterclaim was being pursued. But what we can see is this. Subject to my learned friend's point in relation to the licence to assign, subject to that, the only circumstances in which the court could declare that the defendants were entitled to assign the lease, notwithstanding refusal of consent, would have been if the judge had held they held it as principles. But on the judge's judgment, if they'd held it as principles, consent would have been reasonably withheld. This brings me to the final point, which is my learned friend's challenge in relation to the judge's decision that if the property had been acquired as principles, consent, licence to assign had been reasonably withheld. And my submissions on that are pretty short, which you'll be glad to hear. Essentially, the point is this. This is a challenge to a decision of the judge on a point of fact. This doesn't really get off the ground unless it can be shown that either the judge wasn't aware of a fact for some reason that can legitimately be raised on appeal, or that he erred in giving it insufficient weight. The points which are raised in my learned friend's skeleton argument are, I'm not sure if they're exactly copied and pasted, but they are almost identical with the submissions that were made in closing submissions before the judge. So the judge knew of all of the points that have been raised before you today. The judge is an experienced landlord and tenant practitioner. In fact, I won't go so far as to say he is an eminent, when he was in practice, he was an eminent landlord and tenant practitioner. The suggestion that he was unaware or paid insufficient regard to the sixth proposition of Lord Justice Falk in international drilling is absurd, unless there was something in the judgment to show that he had ignored it or left it out of account. And there's nothing in the judgment that shows that at all. Of course, he didn't address every single point that was addressed to him in his judgment, but his judgment was long enough as it is, and it would have been impossibly long had he done so. So this is something where this challenge to the judge's reasoning just doesn't get off the ground. It's an appeal on a point of fact where there is no error of principle can be demonstrated. Those are my submissions, unless you've got any questions.
No, thank you very much. Mr. Rosenthal, a somewhat new argument has been produced in reply, and I think you're entitled to a brief rejoinder.
Thank you. Your Lordship identified a new argument. Just for what it's worth, I would suggest that there have been two new arguments. I don't have anything more to say about the second one, but it is just worthwhile identifying it as a new argument. If I could invite the court to turn to page 209, please, in the core bundle. This is within the appellant's supplemental skeleton argument addressing clause 6.7. And at the very bottom of the page of clause 6.7, it says, they, the receivers, would be contractually obliged to pay Alma the cost of the works. As correctly noted in Respondent's Skeleton paragraph 52, this would be a contractual debt. And that, and I apologise for having that at my fingertips earlier, that is why I began my submissions on that point, on the basis that I thought that my learned friend was addressing clause 6.2, not clause 6.7. But the ground seems to have shifted somewhat in relation to clause 6.7, but the court has my submissions on the substance of the argument there, given that that ground has indeed shifted. The other new point arises in relation to ground 1, and it is said that the powers that the receivers had did not extend to taking the common parts lease because, as a matter of law, it wasn't necessary for them to hold the common parts lease. And there are a number of building blocks that lead to that, but I can really short-circuit all of those. For this reason, if one goes to the powers, and it would be helpful to have open both authorities bundle page 239, which is schedule 1, and supplemental bundle page 221, which is the mortgage conditions. Even if it is right that the receivers acting on behalf of Alma could have enforced the payment obligation in the deed of maintenance without having the common parts lease vested in them, the receivers were not taking the common parts lease with a view to managing the property indefinitely. As found by the judge, and I'll give you the reference in a moment, the receivers were taking the common parts lease in order to complete the package that they could then sell on to a purchaser. And it was recognised by my learned friend that a third party would not be in the same position. But even if that isn't right, this was all put using the language of necessity. They didn't need to take the common parts lease, and therefore they didn't have the power to do it. That's what I noted down on a number of occasions. That it is too narrow a summary of the express language that is used in the various powers. So if we look at paragraph 17, the power is to take a lease or tenancy of any property required or convenient for the business of the company. And under contractual clause 15 for Roman 4 little a, the power is to do things which seem to the receiver to be incidental or conducive to any of the other functions, powers, etc. And given the potential for argument as to whether or not the deed of maintenance could operate in the way that my learned friend suggests without the existence of the common parts lease, it is clearly, under paragraph 17, convenient, even if it's not strictly necessary in law. And under paragraph 15, 44a, it's clearly something that is conducive to the exercise of other powers, namely the power of realisation of the company's property, even if not strictly necessary. So even if all of those building blocks are correct, we say that that doesn't mean that the receivers didn't have power to take the lease. My lords, unless I can assist further, that's...
Thank you very much. Well, you've given us a lot to think about, so we will be reserving our judgments. They will be handed down in the usual way, that is to say, in draft first, for you to correct typographical errors and transpositions of dates, that kind of thing, but not to re-argue the case. And as I'm sure you all know, that is under an embargo which is strictly to be observed. In addition, at that stage, if you can agree in order consequential upon our judgments, please do so. Otherwise, please put brief submissions in writing. Thank you all again.